Nelson Mandela's eldest daughter, Makaziwe Mandela-Amuah, is in a bitter legal battle with the SA Heritage Resources Agency. She wants to sell some of her father's items. The agency and the Department of Arts and Culture want this halted. Spokesperson Ben Mwasinga joins us now for more on this. Ben, good morning and thank you very much for your time. I must say, this is another very complex one, with Makaziwe Mandela maintaining that your claim to her private property amounts to you acting outside your body's scope, functions as well as powers. But perhaps it would be more beneficial to start with how and when the said items were declared heritage objects, because she disputes this.
Thank you and good morning, Mfundo. First and foremost, Sarah's position is not to dispute the ownership of these objects. The objects in question are, again, within private ownership. The issue at hand is that the objects were exported without a permit. Now, Section 3.5 of the list of types of heritage objects, which is a regulation under the law, states clearly that any heritage objects that are related to significant political processes, events, or figures and leaders in South Africa are considered to be significant and therefore would require a permit for export. So the point to make here is that if these items were being sold within South Africa, she would not require this permit and Sarah would not be in a position to dispute that sale. However, because these items of significance were taken to a foreign country, that is what triggers the National Heritage Resources Act and brings Sarah into the dispute.
I'm sure you would have seen in her answering affidavit, she stresses that she wouldn't have required permits because she was unaware this remains private property, something that belonged to your father, that was given to you like any other young woman would possess some of their parents' property beyond their death. So in that instance, when she pleads the fifth and says, these items are mine, I was not aware, at no point was I told that perhaps my father's pen, my father's key, my father's shirt falls into this heritage category, then I cannot be found wanting or to have violated any laws because I did not know. Did she know that these particular items fell into the category where it was stated to her explicitly?
I'm not aware of whether or not she did know. However, there is a legal principle, which is that ignorance of the law does not exempt you from following it. So therefore, as much as we can be sensitive towards the fact that she may have not been aware of this, the very least that should have been done is a consultation with Sarah so that she could have ascertained what processes to follow in terms of exporting these objects. And I think also, just to further emphasize, that these objects, whether they belonged to former President Thabo Mbeki or former President de Klerk, the same principle would apply, that they would require export as they may be significant. That's the first instance. And secondly, this is part of our national estate. Therefore, all South Africans, and of course, there are other interested and affected parties when it comes to Nelson Mandela, that would also have to be consulted at the very least in terms of exporting of these objects.
There seems to be a number of these objects. Can you share perhaps some of these that form part of this heritage category? We saw in reports that it's among some of those items, among those is his shirt, but there's also a particular pen that was gifted to him. There was also the key for Robben Island. Just talk to us about some of those items.
Thanks. I think you are correct in that a lot of the items, such as T-shirts, signed copies of books, letters, the pen, and of course the key, which is what triggered this entire application, those are extremely significant. The key specifically, I'll speak a little bit more about that, because the key belonged to Robben Island, which is a state institution, and it was a prison at the time. Therefore, the only item in which Sarah is disputing ownership is the key, because we are of the position that the key should not have been transferred into private ownership in the first place. And secondly, there are a large amount of interested and affected parties and individuals that have a lot of sentimental value that comes to these objects, such as the key. You have ex-political prisoners that were doing time with former President Mandela on Robben Island. You have a lot of individuals within political parties themselves that also have a lot of sentimental attachment. And therefore, that's why SARA emphasizes that the permitting process is not to stop the sale of objects. The permitting process is to regulate these processes so that all interested and affected parties are also given an opportunity to express their desirability in terms of these objects being transferred out of the country in the first place. So yes, there are a large number of objects. A lot of them are considered to be significant. But again, as the law states, any objects that relate to former political leaders in South Africa do become significant.
I'm glad that we actually spoke to you, because the clarity was needed. Because for ordinary citizens, some of them were of the view that you now have a struggle hero's daughter who, according to her knowledge, is the owner of this property. It was given to her, it belongs to her, and she should be allowed to do whatever she wants with it. And if perhaps to cover certain costs, in this instance, we understand that they wanted to have a memorial garden in Qunu. If she's able to auction these and be able to sustain or continue in her father's legacy, one would think she should be allowed to do so. But the clarity now is that you're saying you're not intending to stop the sale, but you're seeking for it to be a regulated process where, as you say, affected parties or parties that have an interest in the preservation of these artifacts should at least be allowed to put arguments forward that perhaps, Makaziwe, we shouldn't sell these, maybe you can sell these, or is there any way to keep them in the country, perhaps even purchase them from you, but retain them in the country?
Absolutely. And, you know, this is taking place within a context where in Africa, you look at countries such as Benin, you look at countries such as Senegal, a whole lot of African countries, Nigeria, are trying to get objects that were illegally taken overseas to Europe during colonization. So here we have a young democracy in Africa, and we would want to do our best to ensure that these items that are reflective of our general population, of our history, of our past, are not just simply shipped off to foreign countries. South Africans have a say. This is the national estate of all South Africans. And therefore, as you state correctly, at the very least, there should be consultation with all interested and affected parties. The other thing to note, I think that's quite important here, is that, again, SARA is not disputing ownership, and SARA is not disputing the sale. SARA is simply stating that if these objects belonged to any former significant leader or former significant figures in South Africa, we would still be applying the same principle. So it's not about the fact that these simply happen to belong to Nelson Mandela, who is a juggernaut, of course, and a huge iconic figure in the country. This principle would apply for any artifacts that would also belong to former President Mbeki and former President Zuma.
All right, and we have seen it even in the DRC with Patrice Lumumba's tooth being returned to home soil. So very important conversation indeed. Hopefully we can have legal representatives of Makaziwe Mandela to at least get context from them on this particular case. But thank you very much for your time. That's SARA spokesperson Ben Mwasinga.